Hello, everybody. So, for the last assignment we're going to talk about, or last module, we're going to look at the Open Meeting Act. And the Open Meeting Act is a state law, as we will see. It is not a federal law, so we're definitely narrowing down our discussion to the state level. But this deals with uh, school boards and school board meetings, and this is where schools definitely get involved in the Open Meeting Act. And most recently, um, we saw in the news early 2014 where Janet DeRisi violated the Open Meeting Act when she moved the state school board meeting to Enid, I believe it was. And we'll see why that was a violation of this law. Okay. And in looking at this, I want you to think about what is the intent of this law. And we'll come back to that question toward the end of our discussion here. So what do we mean when we're talking about the Open Meeting Act and involving school boards? So here's what some good information here that brings it into focus a little bit. The invisible government, wrote Walter Lippmann, is malign. What is dangerous about it is that we do not see it, cannot use it, and are compelled to submit to it. Walter Lippmann wrote that. That critique of invisible government underlies Oklahoma's Open Meeting Act, a series of statutes enacted to encourage and facilitate an informed citizenry's understanding of governmental processes and governmental problems. So where this comes in then is the idea of giving citizens the right to know what's happening in their government. And when we're talking about schools, this is obviously the right to know what is happening in the schools. So as you know, the school structure, we usually think of our principal as our boss, and the principal is our boss. But above that is the superintendent, and that's usually where most people stop. But in reality, it's the school board that is at the top of our organizational structure. And the school board is the entity that does hiring and firing, all upon the recommendations of the superintendent and principal, as we learned earlier in the course. And so, for this reason, and when we're talking about schools, we're talking about budgets anywhere from a few million in rural schools up to over $100 million budgets when we get into the urban schools. So, for these reasons, then, school board meetings are open meetings, and there are rules to which school board members must uh, obey, and all this comes under the Open Meeting Act. So, basic requirements for meetings. Uh, and here we're talking about school boards, okay? So we're going to be talking about school boards through this. Though this is government agencies, we're going to be talking about school boards here. Basic requirement, when a majority of members of the board are together, okay? So that in itself brings in the question, if you have a five-member board, and three of them get together, technically that could be seen as a board meeting. And so quite often you'll hear them talk about the fact that they don't get together in private, or they try to avoid the appearance of impropriety by not meeting together as groups. So majority of the board are together. That's why they always look for a quorum. Be held at specified times and places which are convenient and open to the public. Preceded by advance public notice specifying the time and place of each such meeting, and we'll see that there are specifics to all these things. Specify the subject matter or matters to be considered at such meetings. So those are 4 requirements there for board meetings. Some more requirements. The vote of each member must be publicly cast and recorded. And finally, no informal gatherings or any electronic or telephonic communications except teleconferences among a majority of the members of a public body shall be used to decide any action or take any vote on any matter. So by 3 of your board members get together and discussing and deciding how they're going to vote at a basketball game is in complete violation of the Open Meetings Act. And that gets back to what I was saying earlier. That's why they try to avoid that impropriety, if they're cognizant of it, by purposefully not meeting together so that there's a majority at an event. So we're going to look at some of the specifications now to the Open Meeting Act, and we're going to start with notification. So in Oklahoma, notice in writing by December the 15th of each calendar event. So by the middle of December, all the school board meetings for the next year have to be decided upon as far as their schedule, showing the date, time, and place of their meeting. So we already know when all the school board meetings are going to be held for the rest of this calendar year, because that has to be done the previous year. These notifications have to be sent to the county clerk, and if any changes are to be made to the date, time, or place of these regular scheduled meetings, then a notice in writing has to go to the county clerk not less than 10 days prior to the change. And this is where we saw Janet Barisi get in trouble because she made the change. They knew they were going to make the change, they want to understand it, but she made it public just a couple of days before the meeting, which is a clear violation of the Open Meetings Act. And so any administrator with who is cognizant of this and who is ethical, once they're made aware of this, will cancel that meeting. Okay, there's just no way to have that meeting if they realize they're going to be in violation of this meeting act. And again, the whole purpose of this is to be an open book to the public. More on notification. Time limits of agenda postings exclude Saturdays and Sundays and holidays legally declared by the state of Oklahoma. So that's just talking about that 10-day rule. Public notice to be posted in a prominent public view at the principal's office of the public body or at the location of said meeting if no office exists. So where do you put these notifications? Quite often you will see these notifications on the superintendent's door going into an administration building. That's the most obvious place, but for the sake of transparency, I would encourage you to place them throughout your district if at all possible. And one good place to do this would be at the post office. A public library is a good place. Not all districts have public libraries. I worked in rural districts, and in the 3 rural districts in which I have worked, K-12 districts, none of them had public libraries. But they all have post offices. And so the post office would be a good place to put this. And depending on where you are, maybe even a popular cafe if you're out in the rural area. On websites, post information about the date, time, place, and agenda meetings. And you can find these on just about every school website now. What happens if there is a violation of this Notification Act? Well, technically it's a misdemeanor, and the person conducting the meeting has committed a misdemeanor. Upon conviction, that person shall be punished by a fine not exceeding $500 or imprisonment in county jail for a period not exceeding a year. Typically for each count of willful violation of the law. Now, I don't know that anybody's ever been prosecuted under the Open Meetings Act, but legally, the option is there that people could be prosecuted for violating this law. What about types of meetings that we're talking about when we deal with school boards? Well, there are 4 types of meetings that we see here. Regular meetings, which most of them are all regular meetings. Special meetings, emergency meetings, and then continued or reconvened meetings. And so most of the time we'll spend here in the next few minutes discussing the regular meetings, because that's what most of them are, but we'll touch on those other three types. Regular meetings deal when regular business of the public body is conducted, and this is in regard to school boards, this is once a month. This includes summer months as well. Display public notice at least 24 hours prior to such meetings, setting forth the date, time, place, and agenda. Of course, there's already that scheduled meeting on that calendar, but this is saying that you need to display public notice at least 24 hours. And we'll talk about what has to be on that notice. Okay. For example, the agenda has to be on that notice. New business is any matter not known about or which could not have been reasonably foreseen prior to the time of the agenda posting. And there's always going to be a spot on there for new business. The special meetings, when special meetings are called, these are meetings involving the school board that cannot wait until the next regularly scheduled meeting, and they exclude the emergency meetings. Notice that special meetings need to be given at least 48 hours prior to the said meetings. Public notice of date, time to be given in writing, in person, or by telephonic means to the county clerk. And then finally, on this slide, written notice of the date, time, place of the meeting to be mailed or delivered to each person, newspaper, wire service, radio station, television station that has filed a written request for the meeting. So you could go down and file a request, and anytime these meetings occur, you would get a notification, so you wouldn't have to go to the superintendent's office. So the notice is to be given of the meeting 48 hours prior to the meeting. The agenda has to be placed 24 hours prior to the meeting, and only matters appearing on the posted agenda may be considered at the special meeting. In other words, this one is usually called for a very specific purpose, and it's that purpose that they discuss, and no new business can be conducted during those special meetings. And quite often, what we see in special meetings are maybe interviewing potential administrators. We had, whenever I go do school accreditation visits or school curriculum visits, quite often we meet with school boards, and those are special meetings, especially on accreditation visits. We make our presentation to the school board, and that is always on a Wednesday afternoon, and so the school board has to call a special meeting because they never put those meetings on that agenda in December, or on their calendar in December, so they have to call a special meeting when we go do accreditation visits. And so they usually do that the week before we go, and that way it gets posted, it gets published, and the announcements are made, and then we do our meeting on Wednesday. And depending on the school district in which I visited, these meetings will sometimes have, most often they have very few people attend. I was in a school district in Alabama last year where they had a special meeting where we presented our findings to the school district. And not only did the office fill up, but they had the local news media there as well, dealing with accreditation, because that was a big issue. So those are things that you see special meetings for, okay? Discussing employment, usually administrators, if the board wants to interview administrators, or dealing with special circumstances such as accreditation visits and so forth. Emergency meetings are meetings that are called dealing with an emergency, and these are the least common Obviously, schools don't deal with emergencies very often. Any meeting for the purpose of dealing with an emergency, uh, this is the definition of that meeting: a situation involving injury to persons or injury and damage to public or personal property, or immediate financial loss when the time requirements for public notice of a special meeting would make such procedure impractical. I was in a school district where we had an unfortunate accident that was the fault of the weather, not personnel in the district, but unfortunately it took the life of somebody. And so that required an emergency meeting. The 2-day notification for a special meeting was impractical at that point. Emergency meetings may be held without public notice. The person calling such meeting shall give as much advance to the public as reasonable and possible under the circumstances, in person or by telephonic or electronic means. So you can see obviously why I'm calling emergency meetings, and they're not used very often because emergencies fortunately don't happen very often. And finally, a continued or reconvened meeting. And what we have here, meeting in which is symbol for the purpose of finishing business appearing on an agenda of a previous meeting. Quite often, meetings can run very late into the night. They usually start at 7, and I've been to board meetings that run close to midnight. I've heard of meetings going way beyond midnight. And at those meetings, you would simply vote to reconvene at a later time. And that's what we're talking about here. Only matters on the agenda in the previous meeting at which the announcement of continuance is made can be discussed. In other words, no new business, if they haven't passed that yet, can be introduced. They have to stick to that original agenda. And public notice of the meeting, including the date, time, place of the continued meeting, are to be given by an announcement at the original meeting. So once they say they are making a continuance later on, all that information has to come out at that point. So let's talk about agendas then. Now that we see that we're mainly dealing with regular meetings, what about agendas? Agendas shall identify all items of business to be transacted, including but not limited to the proposed executive session for the purpose of engaging in deliberations or rendering final or intermediate decisions on individual proceeding. And we'll talk about those emergency, or not emergency, those executive sessions. Those are special types of board aspects that do not involve the public. But there are certain restrictions on when they can do this. Agendas: if a public body proposes to conduct an executive session, the agenda shall contain sufficient information for the public to ascertain that an executive session will be proposed, identify the items, business and purposes of the executive session, and state specifically the provision of authorizing the executive session. Executive sessions are done to deal with employment. The vote has to be taken in public. They do not go in and vote in executive session. But what the school board does in executive session is go in and discuss employment of personnel in the system. Sometimes the superintendent is in there, but not always. I've seen where superintendents are not in there. Not required to provide an opportunity for citizens to express their view on issues being considered by a public body. And this is an important piece on an agenda. The school board is not required to have public input. On quite a few agendas you'll see public input, but not all of them. And on those that do not put it on there, they're not required by law to have to put public input on their agenda. So they may voluntarily choose to do this if they wish to do so. They may limit the comments to items on the agenda or may allow for comments on any matter. And if the comments are to be allowed, an agenda item which provides for visitor comments or public comments is sufficient. I was in a school district in November yeah, I think it was November of last year, and they had public input, and each person was given 3 minutes to make a statement, and the person got up there and started berating the superintendent. And this school board was pretty divided. It was a 7-member school board, but they were pretty divided. 4 were against the superintendent and 3 were in favor. This is information I knew beforehand. And while I was in the building, they had a meeting, and so I thought, well, I'll just go and listen to this meeting because I had some time. And this particular public member, public stakeholder, got up and started berating the superintendent, and the school board president quickly shut him off and told him that even though they're allowed their 3 minutes to speak, the school board was not going to allow him to berate the superintendent, and that if he had any other comments, he was free to make them, but they were not going to allow him to continue. Of course, he kind of exploded at that point and talked about how unfair it was and so forth. But the school board stuck to its guns on what they could do, and they were legally in the right to do this. And so this was a rather large school district, had over 20,000 students. So I think not allowing public input would have been a little bit of political suicide. So they did allow public input, but they controlled what was said, and to an extent, but they definitely controlled the time frame that it was said in which the comments were made. So talking about executive sessions, as I said, executive sessions have to be noted on the agenda if the board is going to executive session. It is authorized by a majority vote of the quorum of the members present. So they don't just go into executive session. If you ever get to a school board meeting, and they will vote to go into executive session. Of course, they cannot vote without a quorum present. And so they vote by simple majority of those who are present whether or not they will go into executive session. Minutes of executive sessions must be kept. A written summary of the proceedings. So this is what goes into those minutes, simply a written summary of the proceedings. Any person legally present during the executive session of a Board of Education may take the minutes of the executive session. So in other words, anybody who is legally allowed to be in there could take the minutes. And willful violation of the executive session rules means that each member of the public body could be held criminally liable and cause the minutes and all other recordings of the executive session, including tape recordings, to be immediately made public. So there are definitely some safeguards in executive sessions. Okay, this stuff is not automatically made public, as you can see. But if they do anything that violates the law, all of a sudden that stuff becomes public. So what are the purposes then of executive session? Well, as I said earlier, it's basically to discuss employment. Employment can take on hiring new people, appointing people, promoting, demoting, disciplining, or the resignation of anybody in the system. Discussing negotiations concerning employees and representative employee groups. If you're in a system that has union members, that would come into play. Me personally, I've never worked in a system that was unionized. Discussing the purpose or appraisal of real property. Mainly executive sessions are done for the purpose of employment, but you can, by law, discuss property acquisitions. And confidential communications between the school and its attorney concerning the pending investigation claim or action if that disclosure will seriously impair the ability of the school to process the claim or conduct pending investigation of the public interest. So I probably misspoke a little bit when I said that the reason they go into executive session is for employment. That's really the main reason, but they can also discuss these things here. property, communication with legal counsel, um, and these other things here, permitting school board members to hear evidence and discuss the expulsion or suspension of students. Obviously, we want to keep students' privacy rights intact, and so if we're going to discuss or hear evidence of a student's expulsion or suspension, that can be done in executive session. I've seen it done in public, but it can be done in executive session. Again, privacy dealing with handicapped students. And again, basically kind of a catch-all phrase here. Anything that would violate FERPA, the privacy laws of the federal government or the state government. Any communication in the meetings that would violate these would be done in executive session. So the minutes of the meetings, minutes have to be kept by the person designated by the school board. The minutes show clearly those members present and those who are absent, all matters considered by the school board, all actions taken by the board, including how each member votes on each item. These are for the public part. This is not executive session. Shall be open to the public inspection and reflect the manner and time of notice. So all that involves regularly scheduled school board meetings. For emergency meetings, the nature of the emergency and proceedings occurring at such meeting, including the reasons for declaring it to be an emergency. Any person attending a public meeting may record the proceedings of the said meeting if they wish, providing that their recording of the meeting does not interfere with the meeting itself. So you're more than welcome and more than legally capable of simply going in and sitting on every school board meeting you wish and recording them. I was in a school district earlier this semester, and it was interesting because what I found very enlightening in the school district is that the district had a new superintendent. And when I went online to look at the board policies and procedures and so forth, I found a copy of their scheduled meetings for the year. But I also found their agendas, which is a common thing to find on sites. But what fascinated me was that I found video recordings of their meetings. And so talk about being transparent. This district has video recordings of all their school board meetings. So that was very enlightening to see. Teleconferences, we did say that teleconferences were allowed. Each member of the public body is visible and audible to each other and the public through a video monitor. So these are some requirements that teleconferences must include. Must have a quorum present at the meeting site as posted on the agenda, and the agenda must include that it will be a teleconference. So you can have a teleconference, but there are some requirements, and part of that is that everybody must be visible on the screen. At the proposed meeting site, there must be a quorum there, and maybe you're teleconferencing to another member of the board who is not present. And the agenda must include that this was going to be part of the regularly scheduled meeting. The teleconference location, address, and telephone numbers at each site, and identify each member at each site where they're physically present. Some more information about teleconferences, and these, generally meetings are done with no issues, but the technology is allowing the capability of teleconferences, and so board members may find it easier to get away and go to their own personal career meetings or conferences or so forth and teleconference in that way. So this may become more popular in the future. Members can only participate in the meeting as indicated in the agenda. Each site must be located within the district or ward in which the member was elected. Each site has to be open and accessible to the public. The public is to be allowed in the site and room The public allowed to participate at each site in the same manner as set by board policy. All materials are to be made available. Votes to be recorded by roll call vote. No executive sessions are allowed in teleconferences. And that is it. So hopefully what you see then is the whole reason for the Open Meeting Act. The whole reason is, as we saw in that first slide, to make sure there's no secrets hidden in what's going on. And I don't know of any administrators who have issues with this. It's positive practice. You definitely want stakeholders involved, and by following the Open Meeting Act laws, you definitely get them involved. And it makes the school transparent. So hopefully that gave you some new information that you may not have known about meetings and school boards in particular.